Mr. Trevino, if you can remove your cap, please.
Guys, if y'all can just bear with me, we're having some mic issues, but I'll be with you guys here shortly.
Test, test. Can you all hear me?
Yes, I can.
I can see a lot of people have their mics muted.
Yes, I can hear you.
Perfect. I think we're good now. All right, as I was mentioning, we're now live on YouTube. I will ask that everybody please remain on mute until case is called. Once your case is called, you can unmute yourself to identify yourself. Anyone with a quick announcement can give me a reaction button by raising their hands. I see Mr. McLaughlin with a reaction button. What do you have, sir?
Yes, sir. I have CL 196277, and we're just announcing that we are ready for trial. And I believe it is the next hearing is on February 28th.
That Angelica Flores, the case on Angelica Flores?
Yes, sir.
CL 196277H.
Yes, sir.
I'm present, Your Honor.
Was this case transferred?
I believe it was transferred from Court 9.
Court 9
Back to us?
Yes, but we don't have a trial date on our calendar.
Yeah, we don't have a trial date on this one, sir. So it was, so let me get this straight. We send it to Court 9, they sent it back?
I believe so, sir.
Your Honor, this is Angelica Flores, if I may.
Yes, ma'am.
The reason that it was sent back was because I do know the judge, Judge Ocaña, because she used to be my attorney, so she felt there was a conflict of interest.
Oh, gotcha. Okay. So then let me go ahead and give it a DCC,
Okay.
February the 8th at 3 p.m. so we can put it on our docket. Okay.
Thank you, sir.
At 3 p.m. It's a telephonic phone call, Ms. Flores, so that'll be, you'll call into the office and then we'll work on a scheduling order, okay?
I appreciate it, Your Honor. Thank
All
you.
right, yeah, not Zoom, it's telephonic.
Okay.
All right. Anything else, Mr. McLaughlin?
No, sir. That's all I have today.
All right, thank you.
Thank you.
All right, Ms. Vale, what do you have?
Apologize, I forgot to unmute. Cause number F4995-188, Your Honor.
In the
This
interest
is a
of
case-
Judy Jade Vasquez Soto, a child?
Correct, Your Honor. This is the one where he's attempting, he already has visitation rights. She denied him visitation, but the court set up a schedule and they have gone through with the schedule, except there was one Miss Sunday because she thought the child had COVID. His other child did not, but she didn't allow the daughter to visit. But nevertheless, Judge, we'll do makeup. But I think the court had talked about maybe now doing the overnight, which is what he's entitled to, in some type of a graduated form. I think that's what the court was thinking of, if I'm not
Okay.
mistaken.
And is George Munoz still on the other side?
That I know of, yes, Your Honor. I've not received word otherwise.
All right. Have we heard back? Anybody from the office heard back from George or heard from George? All right. Let's hang tight. It's only been 10 minutes since we.
Your Honor, I have another case. If I may be excused and go to county court number 9, I will come back because the counsel over there is also running late.
Okay, no problem.
I'll do the best I can.
Sure, no problem.
Thank you, Your Honor.
You're welcome. All right, anyone else ready to make an announcement on their case? If not, I will go to Mr. Gomez. Mr. Jose Gomez.
Your Honor, good morning.
Morning.
I've got F2777-178 set for a status hearing today.
All right, in the interest of Jasmine Hope Martinez.
I do not see the mother who is pro se on the screen.
We set it up, Judge, because Mr. Gomez has been trying to do a DCC. He couldn't reach the person, so I set it up for status in person so the person can come in.
All right, is she, what is her name, Mr. Gomez?
I just know her as Miss Martinez, Mrs. Martinez. I don't have her first name.
All right, is there a Miss Martinez who is here in the interest of Jasmine Hope Martinez, a child? If you're on mute, please unmute yourself.
Rosario Annette Martinez.
Rosario Annette Martinez. Rosario Annette Martinez. If you're present, please unmute yourself.
She may,
Okay.
she may need an interpreter, Your Honor. I'm not certain, but I would suggest that the call be made in Spanish as well.
All right.
Rosario Martínez, si se encuentra, por favor, identifíquese. Rosario Martínez.
All right. So Mr. Gomez, you've been having some difficulty reaching out to her and making contact, I suspect.
Yes, Your Honor.
All right. And obviously this is to hold a DCC at this point. Let's just hold a DCC without her. She's been given every opportunity to present herself and has failed to do so. And you've had some difficulty reaching out to her. So we will go and we will keep moving this case forward. So we will proceed without her. I don't know if you want to do that. If you can maybe call the office right now. I have no problem with you calling in the office and taking care of that so that we can accommodate your schedule.
Very well. I'll call the office as soon as I get off.
Okay, perfect. Thank you, sir.
Thank you very much. May I be excused?
You're excused.
Thank you.
All right. Let's see, what else do I have here? Mr. Davis.
Yes, sir. Good morning, Judge.
Good morning. What do we have?
I'm here on a F0620-21-8.
Give me 1 second. F 20
0620.
number 6. All right. It's in the matter of the marriage of Amanda Garcia and David Garcia.
Yes, sir, Judge. I was just, Marco De Luna filed a motion to substitute for David Garcia. So
Okay.
I assume he will be taking over the case for Mr. Garcia and I'll be leaving it.
All right. And this is the one with Ms. Diaz.
Yes,
I'm
sir.
present, Your Honor, and so is my client.
Okay. What is left to be decided on this one? I thought this one case was going to get settled or not settled, but there were some issues with respect to child support that I already took care of. And there were some issues with respect to a closing of a house that I had already ruled on. Oh, Mr. De Luna just walking in.
Okay.
We're going to set up the tablet. Give me 1 second. So what's the issue here? And Mr. De Luna, you're now present here. Mr. Davis is announcing that he is that you're going to be substituting in for him.
That's right. We filed a motion to say, but from what I know, that all that was said was my motion for substitution.
Okay.
Sorry, Judge, I couldn't hear Mr. De Luna.
He says that his understanding is the only thing that was set this morning was his motion for substitution. And that's true. That's the only thing that's said on the motion. I just my issue is I thought everything had already been decided. I didn't know we needed to deal with any other issues.
Your Honor, the last thing that the court was trying to resolve was in reference to the child support amount. The court might recall that we were not in agreement with the amount of child support. Since that time, I had spoken to Mr. Davis regarding that. But then the last time that I tried to talk to Mr. Davis, he was no longer going to be on the case. So I was left in limbo of, do I discuss it?
No, hold on, huh? You were upset at amount of child support because I based it on minimum wage, which it can't get any lower. So I mean,
That's exactly my point, Judge. That's exactly what I told Mr. Davis. And I told him that I even sent him an email saying that we were accepting him a minimum wage because the judge basically had already said he was going to order it at that. But he said we still didn't have an agreement. And I just kind of was left in limbo. So we're appearing today. My client and I were already aware of that. But then we were told that Mr. Davis said that I never responded. And I have an email telling him that we were accepting minimum wage because the court basically ordered it.
Just to be fair, though, you were upset at the fact that I was contemplating minimum wage and you wanted to bring in a witness from L&F Distributors to testify. Or I suggested that you bring in that witness. You were going to reach out to him. I think you may or may not have reached out to him. You may or may not have had a conversation with him about why he was not employed, right? Or an offer wasn't extended. I don't know that communication. That's attorney-client between you, your client, and this other individual. But you chose not to have a hearing in which to bring in this witness. correct?
That's correct, Judge. Yes, and that's why I sent Mr. Davis an email that based on what this witness was, all the witness really told me was he didn't get the job and he wouldn't tell me why. And so based on that information, I had already argued to the court that I thought looking for one job was not sufficient, but the court had already basically let us know what it was going to rule. And so when I spoke to Mr. Davis, I said, my client is not wanting to waste any more time or attorney's fees, so we're agreeing to the minimum wage at this time since it's temporary orders. And then here we are today.
Yes, you can unmute yourself so that, and I'll mute myself so that there won't be any interference.
Judge, Marco, Judge, if I may, I was involved in the last hearing that we had at the time. After that apparent hearing, when Mr. Davis still represented my client, which is not my client, if the court lets me substitute it today, there was, as of what he told me that day, that there was still a disagreement, and they were going to be having a hearing on the child support amount, and whether he was being underemployed on purpose and all that kind of stuff. So he did discuss that with me, but again, I had no emails from anybody or anything. Again, that's why I'm here today to substitute in. But he himself, I should say, the client said that he had no idea whatsoever about any, where Ms. Diaz was going to just say, okay, we're going to go ahead with a minimum wage part. Not only that, Judge, he was going to have I was brought on, and we were going to be, I believe that he was in agreement with Mr. Davis in some order that was signed that he believes that it was not what was ordered. But Mr. Davis did sign off on it, and it asked for a $10,900 extra that was supposed to be coming out from the equity of the home. So there was stuff that was still pending. So it's not just a closed case. I mean, I'm coming on board today again just for the motion to substitute. But according to my client, again, I wasn't at that hearing. I literally today would be the first day coming in. Is that the order that was signed by Mr. Davis and Ms. Diaz wasn't what the court ordered. That may be the case. That may not be the case. But that being said, that's why I'm asking to be put on the case, and then at this point we can start working. If we're going to either agree to the finality of it, or still continue to fight for what he believes that extra monies that were taken away from the sale of the home.
Judge, I'm going to object. That's not the argument. We're here before the court. Judge, I'm going to object. He's making an argument before the court that is not before the court this morning.
You're asking me what you're saying, that the case is closed, Judge, and I'm trying to tell you, explain two reasons why it's not closed.
No,
that's
just
exactly
in reference to child support, Judge.
Okay.
And Judge, I do have the email that was sent January the 25th at 4 o'clock telling Mr. Davis that my client, it says, therefore, my client is forced to accept child support and minimum wage, and I asked him to send me the calculations. I then even called your court to let them know that we had agreed on the minimum wage and therefore would not need a hearing. I think Mr. Villanueva will know that I did that.
Okay. Yes. So, Mr. De Luna, what I can suggest to you in terms of the issues with respect to the sale of the property is I've already heard that. That's already been dealt with. Mr. Davis represented your client now, and I will tell you that my suggestion would be to go and pull the transcript.
And I plan to, Judge.
Okay, I think Ms. Diaz has already requested one from our court reporter, and I can tell you that that is what it is, okay? I'm not gonna change my opinion about it. It is what it is. The court already made a decision on it. And the only issue that was still left to be decided was child support. I'm basing it on minimum wage because I feel that your client has sought employment. Ms. Diaz was upset about it, adamantly objected about it. She advocated for her client, and I ruled the way I ruled. And so at this point, I don't know what is left, what loose ends are left to be tied. But having said all that, you're more than free to pull the transcript.
Thank you, Judge.
And tell you that probably.
Judge, just so the court is aware, I'm not here to tell you. That's what Ms. Diaz said that I'm arguing. I'm not here to tell you what you did or what you didn't do. What I'm trying to tell you is that my client is saying that the order that was signed off on, that was used to close on the house yesterday, that I helped on, even though I wasn't part of the case, that it was incorrect. It didn't mirror the order, what you had ordered. That's what I'm saying. I'm not making an argument. I'm just saying that's why I'm here.
It's possible that the order.
Sure, of course.
Was not in compliance or in conformity with what the court ordered.
That's all I'm saying.
I had nothing to do with that. It's possible.
And I had nothing to do with that, Judge. It is possible.
That he's upset about it or that he thinks that the outcome is going to change, that's not going to change. But if it's wrong, if it's incorrect, that's correct.
Thank you, Judge. And that's all I'm at. Like I said today, I mean, the only reason I wasn't trying to argue with Diaz or make argument with the court. I'm just saying we believe that there's a reason why that. I mean, we're going to continue the case. All I'm asking is to be able to substitute to be substituted in for Mr. Davis, and I'd be given that opportunity. That's it.
All right, the substitution is granted.
Thank you, Judge.
All right, Mr. Davis, do you have anything to add?
No, that's all, Judge. May I be excused?
You're excused.
Thank you.
Okay. Ms. Diaz, does that leave us with anything to deal with today? Probably not.
No, Judge, and that's not what Mr. Deluna said. We understand the case isn't over, Judge. It wasn't a final hearing. This was just for temporary orders.
Okay. Maybe that was my mistake too, because I thought it was.
The child support was just for temporary orders.
It's just so the court is aware again, but the problem is, I understand that. I believe it's also, but Judge, the problem was that there was a sale on a property on an order that was signed. That there was a finality when it comes to the actual property itself, even though it was under temporary orders. You understand what I'm saying? It wasn't like we did temporary orders and okay, now we're done and whatever. No, there was a sale of an actual property that was done while the divorce itself has not been completely finalized. So again, there's without going into what defenses I may have, but there's things that are still possible to be filed with the court to entertain certain things that were done or not done or should have been done or maybe shouldn't have been done when it comes to the case.
How long before this case is finalized? And should
Judge, I believe that we already have a setting in April.
Okay. Do we have the date on that? Give me 1 second so I can have it.
I believe it's April 27th, Judge, but I may. Yes, it is April 27th, Judge, at 2:00. It's a bench trial.
Okay, and I do want to thank Ms. Diaz, Judge, because apparently we filed a motion for substitution. I guess it wasn't served upon her, and I apologize that my office might have just filed it directly with the clerk's office. So I do apologize for that, and I appreciate the fact that she showed up and for this hearing again, not having been fully notarized about the substitution.
Okay.
I did tell him, Judge, I had no objection, Judge, for the substitution.
Sounds good. All right. Thank you.
Thank you, Judge. Maybe
Thank you, Judge.
Thank you.
You put that on. All right, who else is here that's ready to have their case called? All right, Mr. Daniel, is it Cement?
Yes,
Did I
Your
pronounce that
Honor.
correct?
Yep,
What case are you here on?
it's CL 211732.
Security First Credit Union versus Sergio Garza?
Yes, Your Honor.
All
And
right,
Your Honor, Michael Weems for Service First Federal Credit Union. Good morning.
Michael Weems, let me see, there you are. All right, and this is plaintiff's motion for summary judgment, is that correct?
Yes, Your Honor. Defendants have filed an objection to today's hearing, so I'm sure Mr. Cement probably wants to address that with the court, and then we can review from there.
Okay,
Yes, Your Honor. Thank you. I think it makes more sense to deal with the objection first.
go ahead.
Our objection is to the notice that we received for this hearing. The notice we received was on January 28th, which is less than 21 days from today. And under Rule 166A, we're entitled to 21 days notice of a hearing on a motion for summary judgment.
That's absolutely correct. I'm not sure why we did that. We know why we did that?
And I'm not sure why opposing counsel is arguing with this either and filed a response opposing it. I think that's kind of wasting everybody's time, including the courts today.
Well, Your Honor, perhaps I'm misunderstanding, but we filed the motion for summary judgment January 7th, 2022. The e-service shows that Mr. Cement got the notice of the motion itself with all attached exhibits and affidavit on January 10th, that it was opened by email. My understanding, although I could be incorrect, is that the court then issued an order for a hearing for today. I think they may have had an incorrect time at 9 a.m. I believe that was emailed to the attorneys. Mr. Anthony Garcia with our firm was plaintiff's counsel. It appears, we talked to the court yesterday because we could not find a copy of that particular January 10th notification in our records. it looks like they may have had Mr. Garcia's email incorrect with our firm. So that may be why we did not send out the notice of hearing once we got notice of it. But my understanding was, and again, I may be understanding incorrectly, was that defendant's counsel also got notice by the e-service system on January 10th or by the court. If that's incorrect, then I apologize, but we didn't do a separate notice of hearing because our records are not showing that we got that initial one. There was a revised notice done yesterday, well, a day before yesterday, I think. As soon as we got that, we emailed it to Mr. Cement. We also mailed it, certified mail, first class mail. It's just that initial January 10th setting that perhaps has an issue. But again, I don't know. If the court sent that by email, then I believe he had notice.
Your Honor, the only notice that we received was, I believe, on January 28th for the hearing today. We never, and if you look at that in that order that you signed on January 28th, Your Honor, was originally the hearing was set for February 1st, yesterday, and then it was reset to today, the February 2nd. We never received any notice for the hearing on January 10th. I searched the court's docket. I didn't see anything on the docket showing a hearing on January 10th. Or a notice on the 10th. I mean, that's just.
Okay, look, out of an abundance of caution, and just so that we can all be on equal playing field and everybody's on the up and up, this is not one of those things that is that I need to have a rule on it today or listen to it today. I'm going to reset this summary judgment to February 23rd at 9:30. That gives everybody enough time. And everybody gets notice. It's a public notice here today, February 23rd, 9:30.
Thank you, Your Honor.
All right. Thank you, guys.
Thank you. Can we be excused?
You're both excused.
Thank you.
All right. Anyone else ready to have their case called? I just need to get a reaction button. Ms. Villanueva, Jenny Villanueva.
Yes, good morning, Your Honor.
Good morning. What case are you here on?
I am here on case CL-21-4062-H.
All right. The state of Texas versus, you pronounce it Jenny or Jeannie?
Jeannie
Tijerina Villanueva. A petition for non-disclosure.
Yeah.
All right. And do we have anybody from the state present? See if they object. Give me 1 second, ma'am. I'm going to contact the state of Texas and the I guess my office, we sent a notice? Okay, yeah. So my prosecutors need to see if they have any objection. I need just to check with them to see if there's any objection. Give me a couple minutes and they should log on, or they'll tell me that there's no objection, then I could take on some testimony from you.
All right. Okay. Thank you.
All right. Carlos, are you ready to have your case called?
Judge, good morning. Carlos Ortegon. I know Mr. Contreras is also involved in this case. In fact, he's the lead attorney for the Guerras.
He's here present in the courtroom.
Is he in the courtroom?
Yes.
Okay.
So I'm going to have him, let me see if I can see him on my screen. I want to make sure that y'all can see him as well. Why can't we see that screen? Eddie, I can't see that screen.
Okay, perfect.
Just a baby.
Okay, so I'm going to just place myself on mute just so that there won't be any interference. And I'll continue to speak. You all should be able to still hear me even though I can't hear you. We have Judge Contreras here present in the courtroom. I have Mr. Ortegon. Ms. Gonzalez, you're also in this case. Can you hear me as well? Savannah, can you hear me? Okay, I need Ms. Gonzalez to log on. Ms. Gonzalez, if you're in another courtroom, can you just give me indication that you're in another courtroom by turning on your camera? Let me know that you're in another courtroom. That way I can move on to another case real quick. All right, Judge, can you bear with me? Let's wait for Ms. Gonzalez.
No problem. Just, it said for status hearing this
We
morning.
are set for status.
Some
yes.
documentation.
Status on yes, on the correspondence between the attorneys.
Yeah.
Yes.
I'll be back,
All right.
Judge.
Hi, sorry, Judge, we're
Oh,
having
okay,
a
never mind.
plumbing emergency at my
That's,
office.
Okay, Ms. Gonzalez, you're here on CL 203628H in the estate of Hector Guerra, a deceased individual. I have Judge Contreras is present here in the courtroom. You're virtual, as is Mr. Ortegon.
Yes, Judge, we were ordered to get a letter of, essentially like a proposal over to Judge Contreras. We have not been able to do that. Some of the things that my client requested are outside the scope of this court's authority. So unfortunately, I've not been able to meet with her to discuss those things. At this time, Judge, my primary focus is to get an update on the remains and any funeral services. The remainder, I think, as I mentioned, is outside of what this court can actually do. So if we can get a response to that within the next maybe 2 days, I'd like to set this matter for final hearing after that and see what all we can get resolved. I don't know Mr. Ortegon's position on the sanctions that previously were addressed and where he stands. And then I did want to address one other matter. My client reached out to Mr. Ortegon. He immediately notified me and advised that he did not communicate with her. But I just wanted to put that on the record, given that this case has gotten some unnecessary judicial attention.
Okay. Carlos?
That's correct, Your Honor. I notified Ms. Gonzalez, and there hasn't been any more issues. I just wanted to be upfront with opposing counsel.
And I appreciate that very much. I did advise Ms. Gomez that she is not allowed to talk to opposing counsel's attorney, given that she has counsel.
Okay, perfect. Okay, Judge. I think if you can unmute yourself there, so that
There's the echo that I'm.
Okay, go ahead.
Judge, I'll send a formal letter within the next 2 days regarding the whereabouts of the remains. I know where they are. They're with the mom, but I'll send a formal letter anyway, so she can have a paper. We can have a paper trail for her client. But again, the remains are with mom.
Okay. Okay.
Isela Garcia.
All right. Savannah, so then I guess what you're requesting, and I guess what I'm listening here is that we probably need to have a final hearing on this in about 2 to 3 weeks.
I'm asking 3 weeks. Yeah.
3 weeks. Ready? February 23rd, 2022 at 9:30.
February.
All right. Any issues?
Judge, is this going to be for a final hearing or just another hearing?
I will leave that up.
I think
to
final
your
hearing, I don't know what else we would have left to resolve other than just finalizing the case.
Okay. Well, I'll be calling you as well, Ms. Gonzalez, and we'll have a better understanding. Okay. So February 23rd at 9:30.
Yes, February 23rd, 9:30.
Okay, Judge.
Okay.
Thank
All
you,
right.
Judge. Appreciate it.
Thank
May we
you.
be excused?
You're excused. Thank you so much.
Thank you.
Thank you.
Okay, Jose is, yes. Jose, I had previously called CL 214062H, State of Texas versus Jeannie Villanueva. This is a petition for non-disclosure. Ms. Villanueva is present. She's online. Does the state have has the state reviewed the non-disclosure and have any objection to it?
Yes, Judge, I have reviewed the petition of the non-disclosure. The petitioner was placed on deferred adjudication for a theft in 2015 and completed her deferred period in 2016. I reviewed all the applicable law in regards to this non-disclosure, and at this time I have no objections to a non-disclosure, Judge.
Ms. Villanueva, the court's going to go ahead and grant your non-disclosure at this time. I'll sign off on an order. Was an order submitted? All right, order has been submitted. I'll sign off on it. Since you're appearing pro se, you can get a certified copy from the clerk's office this afternoon, okay?
Thank you so much, Your Honor. Thank you.
You're welcome. Thank you.
Your Honor, having nothing more before this honorable court, may I be excused?
You're excused. Thank you.
Thank you.
Let me see, I have a marriage. Let me call, I see Robert Lee, I believe it's Huber. All right.
Yes, sir. Yes, Your Honor.
Do you pronounce your last name Huber, sir?
Yes, Your Honor, that's correct.
Okay. This is 438528 in the matter of the marriage of Robert Huber and Elizabeth Huber. Is Elizabeth Huber
Yes.
present?
Yes.
Okay, I have it under Liz. This is set for final hearing. Decree was filed. Let me just take a quick look at it real quick. All right, agreed final divorce. Go down to the last page. Signed, it was been signed by both parties. Are you all both ready to proceed?
Yes.
Okay.
Yes,
Can I
Your
have
Honor.
both of you please raise your right hand? All right. Do each of you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? I'll start with Elizabeth Huber
Yes.
and Robert Huber.
Yes, Your Honor.
Mr. Robert Huber, I understand that you are the petitioner in this case. Is that correct?
That is correct, Your Honor.
All right. I'm going to have a couple of questions for you. Please listen carefully. And Ms. Huber, if you have any objection or disagree with any of these questions or answers, please let me know and we can work through them. I'm going to be looking at my sub screen that I have over here, and I'm going to be kind of walking through the decree as quickly as I can to try to expedite this for both of you. Mr. Huber, you are the petitioner in this case, is that correct?
That is correct, Your Honor.
Prior to filing this petition for divorce, had you lived in the state of Texas for 6 months?
Yes, Your Honor.
All right, and in the county of Hidalgo for 90 days?
That is correct, Your Honor.
During the course of your marriage, were any children born or adopted?
No, Your Honor.
All right, and are you, to your knowledge, is Ms. Huber expecting any children at this time?
I believe not, Your Honor.
Okay. During the course of your marriage, was any community property acquired?
Yes, it was, but then we were released from it.
Okay. I'm looking at the decree that you all have submitted to the court for consideration. It looks as if there is some division of property that you all have already come to an agreement with respect to that division. Is that correct?
That is correct, Your Honor.
And you all have laid that out in the final decree of divorce. Is that correct?
That is correct.
And does that include all division of debts and everything that you all have acquired and are seeking to divide at this time?
That is correct, Your Honor.
All right. Has your marriage to Ms. Huber become insupportable as a result of a conflict of personalities? And are you asking the court to grant you a divorce?
That is correct, Your Honor.
There's no expectation of reconciliation. There's no expectation that both of y'all are going to get back together.
No, Your Honor.
All right. Now, Ms. Huber, I'm noticing that on this decree, you are not requesting a name change. Is that correct?
That's correct.
All right. And you're not seeking to get a name change at this time. Is that correct?
No, no.
And you've heard everything that Mr. Huber has put into the record. Are you in agreement with that?
Well, you said if we had any children during the marriage, and we have had one daughter, but she's 30, so it's.
Oh, okay. So there's nobody that the court would have to consider
Yes,
under the age of 18.
correct.
Gotcha. All right. Anything that you would like to add before the court pronounces judgment on this?
No, I'm fine with everything.
You actually had the opportunity to review the final decree and you signed off on it. Is that correct?
Yes, that is correct.
And Mr. Huber, you had an opportunity to review the final decree of divorce and you signed off on it. Is that correct?
Yes, Your Honor, that is correct.
Court's going to go ahead and grant the divorce at this time, along with all relief that's been read into the record and prayed for by way of the pleadings that you all have entered with the court. I will sign off on it. Both of you, I will sign off on it right now. Electronically, we'll send it over to the clerk's office. You should be able to get a certified copy this afternoon.
Okay.
All right. Good luck to both of you.
Thank you.
You all are excused.
Thank you. Thank you.
Okay, let me see. Do I have any other attorneys who are ready to make an announcement? If not, let me see if I have any other matters. Let me see. Number 4. F-4562-21-8 in the matter of the marriage of San Juanita Cantu and Raul Heriberto Cantu.
Yes, that's correct, sir.
All All right, good morning, Mr. Raul Cantu, and I think I have San Juanita Cantu there, who is still on mute. If you can unmute yourself, Ms. Cantu. This is also another pro se divorce. Give me 1 second while I look this divorce up. And all right, Ms. San Juanita Cantu, you are the petitioner in this divorce, is that correct?
Correct.
All right, and very similar to the last divorce, I'm going to be asking you a series of questions. Please listen carefully, Mr. Cantu. If you have any objections or you have any questions, please go ahead and let me know, okay?
Okay.
All right, perfect. Ms. San Juanita Cantu and Mr. Raul Heriberto Cantu, can I have both of you raise your right hand? Do both of you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? I'll start with Ms. San Juanita Cantu.
Swear.
And Mr. Raul Cantu.
Yes.
Thank you. Ms. San Juanita Cantu, you are the petitioner in this case, is that correct?
Correct.
And prior to filing this petition for divorce, had you lived in the state of Texas for 6 months?
Yes.
And in the county of Hidalgo for 90 days?
Yes.
During the course of your marriage, were any children born or adopted?
3.
Okay. And are any of those children under the age of 18 or still in high school?
1, but she's a mom already, so I think she's emancipated.
Okay. Let me see if how you listed her on your final decree of divorce.
I think I did not because since she already has a baby.
Okay. And how old is she?
She's 17. She's gonna be 18 in March.
Okay. During the course of your marriage, was any community property acquired, Ms. Cantu?
Yes, but everything was sold already.
Okay. And anything that remains and anything that you seek to divide, you've done so by way of the final decree of divorce that you submitted to the court. Is that correct?
Yes.
Okay. And has your marriage to Mr. Cantu become insupportable as a result of a conflict of personalities? And you're asking the court to grant you a divorce. Is that correct?
Yes.
And there's no expectation that you all will reconcile and get back together?
No.
And are you asking for a name change?
Yes.
And you're seeking to have your last name of Flores restored, is that correct?
Correct.
All right. And did you have an opportunity, you prepared this final decree of divorce, did you have an opportunity to go over it?
Yes, a little, yeah.
Okay, because you signed off on it and you're asking the court to grant the divorce, is that correct?
Correct.
All right, Mr. Cantu, do you have any questions about the final decree of divorce?
No.
You
No,
signed
sir, I
off
don't.
on it too as well? Is that
Yes.
correct? All right, and you're asking the court to grant you a divorce?
Yes, sir.
Court's going to go ahead and grant the divorce along with all relief that's been read into the record and prayed for by way of pleadings. The divorce is hereby granted. I'm going to sign off on it here momentarily. You should be able to get a certified copy this afternoon, okay?
Thank you, sir.
Okay.
All right.
Can we be excused?
Y'all are excused. Yes, thank you.
Thank you. Bye.
From my office, any word on George Munoz logging on for Ms. Vale? She's back. Ms. Vale's back. Ms. Vale, can you reach out to George's office and see if maybe you can help us? Okay. Oh, he's in County Court 7, so now he's live and in person now. Okay. Let me see, who else do we have here that's ready to make an announcement? All right, I have a Julissa Mata. Ma'am, what case are you here on? Can you unmute yourself?
Good morning, Your Honor. Itzel Martinez for petitioner Julissa Mata, who's the mother of the child in the interest of Isla Faith Nash.
Okay, perfect. All right, so Julissa Mata is here for Isla Faith mother. Okay, and who's on the other side of this one, Ms. Martinez?
It's Miss Tanya Ramirez. We're before you today on her motion, Judge, to modify your temporary orders.
So Tanya Ramirez. I think I have Jonathan Munoz is present. He was here in the courtroom, but to avoid the interference with us being in the same room and the audio, I've asked him to go into the jury room. I think he's going to be setting up in the jury room here shortly. I'm getting a message from Talia Ramirez. It says it doesn't work. I'm not sure what she means by it doesn't work.
She was saying she can't hear anything. I had asked her to log up and log back in.
Hello?
Yes.
Sorry, let me close it.
All right, I can see you there. Mr. Munoz?
Yes, good morning, Your Honor. Jonathan Munoz on behalf of counter petitioner Austin Nash.
All right, what is your client's name? Austin? Austin
Yes,
Nash?
yes, Your Honor.
All right, Austin Nash. Perfect. Okay, so I have Mr. Austin Nash on. I have Julissa Mata on. I have Ms. Martinez, and you're here for behalf of your client. What do we have here this morning?
Your Honor, we have a contested temporary orders hearing.
Okay, what's contested about it?
Your Honor, I don't believe we need testimony, but the issue right now is just that my client, you granted him overnights sorry, not overnights. You granted him visitation for several hours, I believe 9 a.m. to 6 p.m. on Saturdays and Sundays, every weekend starting on September 29th. And now we just want to start transitioning to a schedule where he's allowed and permitted to have overnights.
All right. How have the visits gone?
Your Honor,
that we granted?
Your Honor, if I may, the last hearing before you was also a hearing for temporary orders where you ordered what Mr. Munoz just mentioned, the Saturday and Sunday. So every weekend, Saturday and Sunday from 9 to 6 with no overnights. Your reasoning for no overnights was based on the fact that dad and child had not had any contact during the previous year during COVID and all that. We are before you again today on the same issue of overnight visitation. Respondent has insisted on overnights and has been demanding overnights since you entered your order for visitation. My client has not been in agreement, and it's for two primary reasons, Judge. The first reason is that respondent continuously refused to disclose his address while still demanding overnights. It wasn't until we went to mediation, which was, December 28th or 29th, I believe, where Ms. Del Bosque, the mediator, was able to explain to Mr. Nash that the law requires him to disclose his address. And so rightfully, Ms. Mata was not willing to agree to overnights because Mr. Nash refused to disclose where he was living. So Ms. Del Bosque finally was able to explain to Mr. Nash that he is required to disclose this information under the law. And so since then we have had the address, which brings me to the second point, Judge, for no overnight visitation. It's not in the best interest of Isla right now. Since she started visitation, since this order started back in September, she has began developing night terrors and a speech stutter. So it's a visible impairment that she's started to develop, which are signs of maladjustment to the new changes. My client has taken her child to the doctor, has seen her doctor about 3 times on this issue. The doctor recommended as much consistency and routine as possible and recommended a child psychiatrist who she's on the waiting list to see. It's about a 3-month waiting list, Judge. I guess child psychiatrists right now are in high demand, and there's a long waiting list to be able to get a doctor's visit with one. In conclusion, Judge, respondent hasn't met the legal standard to change temporary orders. The legal standard requires that there has to have been a material and substantial change in circumstances that warrant a changing of temporary orders. So for those reasons, Judge, we would respectfully request that you set this hearing for final hearing, like a trial, so that we can submit final orders, put on evidence for all the issues that still have to be decided, and just continue the current orders of, visitations on weekends from 9 to 6, and by any other days by mutual agreement is what you ordered at the last hearing, Judge.
All right, Mr. Munoz?
Your Honor, if I may respond, I don't discount opposing counsel's representations, but I mean, I don't believe they submitted any sort of evidence or report regarding connecting her visitation with my client to these night terrors. I mean, children obviously have to adjust to new circumstances, and honestly, it's impossible for her to adjust with absent overnights in the first place. I mean, that's why the code contemplates first, third, 4 overnights at least a month. I mean, so I don't know where that argument leads us. And regarding the address, I'll just say this: opposing counsel, I mean, I didn't even know that the address information was an issue until about prior to mediation. So I don't believe that's a justifiable reason to be unwilling to pursue overnights. And if her only reason to deny overnights is because of potential night terrors or some sort of maladjustment, I mean, that cuts the other way too. How is she going to adjust with Mr. Nash as a father unless he starts overnights at some point? Because from what I understand, from my understanding of that argument, then they just want a final hearing where he doesn't get overnights at all. And that's not in the best interest of Isla.
And that's not our position at all, Judge. My client wants to establish overnights. She wants to have, a good relationship with dad and with child. She's not trying to withhold him. There's been even times where she's considered giving him an overnight during this time. But when she speaks to the child and she tells him, you're going to be over at your dad's house. We're not going to be there. You're going to stay overnight. The child does not react well, Judge. So.
And Your Honor.
Go ahead.
Well, first, Your Honor, for purposes of the record, I did submit an exhibit list. They're labeled exhibits A through E. They were exhibits I submitted for the mediation. And they're agreed to. They're just copies of his work schedule and pictures of his home, where he would have the overnights with his daughter. So I don't know if you want to question counsel, she'd be willing to admit those.
Okay, let me ask you this question. How were the visitations that have been taking place since September? How have those gone? I mean,
they've gone well, Judge. I mean, the child is being transitioned well, drop-offs. There has been some issues. I'm not going to lie. Like, it hasn't been smooth sailing. There's been a lot of contention and conflict between the parents. My client has represented that she wants to try to do maybe a parenting class because there is so much conflict between the two parties. But as Isla, there has not been an issue with the child, visiting dad. So
how old is the child?
She just turned 3, Judge. So
3, Your Honor.
She is very young. She just now started qualifying for this standard possession order.
And Your Honor, I mean, just for full background, I mean, because there's a lot going on. I mean, as far as her environment. And when I say that, I mean, Mr. Nash, he does have a fiance, and they live together, and she has a kid as well. But Jalissa as well has, I think they're married now. And I think he also has kids too. So I'm just saying I think it's unfair and unjust to sort of, pin all her night terrors or maladjustment issues on starting visits with her father. Because I mean, I might remind this court, for the first year of her life, they lived together. For the first year of their life, he did have her, he did know her.
And then they separated, and then at that point, mom went her way and dad went his way. And then it wasn't until the attorneys got involved that, you know, you all started to seek to try to bring the family,
Yes.
the family unit.
That's
I'll
right.
I'll bet not together, but the family unit and dad and child back together.
That's correct, Judge.
All right. And so how many visits has he had with the child since September?
Almost all the weekends he was able to meet. There was representations that he was not going to be able to change his work schedule, that there was no way to change the work schedule. He managed to.
Is this a case where I told him if he wanted to visit, he'd make the time and he'd do whatever he needed to do to be the parent?
That's correct, Judge. So he was actually able to change his schedule. In fact, every weekend he was basically allowed to visit.
Let's applaud him. Let's congratulate him. Let's not use that against him.
And Your Honor, and that's why
that representation that he was not able to make any changes to his schedule, and that's why he was, you know, trying to fight for specific scheduling dates that would solidify the days he was not working versus the days he was working.
And Your Honor, I understand. This is my thing. I understand your position. I understand what your client's position is. I understand why you're advocating the way you're advocating. I get it. I understand. But at the end of the day, there's been weekend visitations since September. If Mr. Munoz, if you had to give me a number, how many visits have we had since September? Every weekend, Saturday, Sunday.
October, November, December.
Yeah, September, October, November, December. That's 4 months. So
at least 15, I would say.
I'm bad at math. That's why I became an attorney, Your Honor. So.
Okay, so would we agree that it's been 4 months?
Yes.
Yes.
And would we agree that every month has 4 weeks?
Yes.
Yes.
Okay, so 4 times 4 is 16?
16, yes.
Okay, times 2? 32?
No,
30.
30.
Do we agree that it's more than 25?
Yes, Judge.
Yes.
Okay, so more than 25 visits, and those visits have all gone relatively well. Could we agree on that?
Yes, Judge.
Okay.
Yes, Your Honor.
And so now at this point, the question becomes, we've had good visits. At a minimum, it's been 25 visits. Let's start talking about overnights, guys. I mean, we need to start ripping the Band-Aid off.
I agree with you, Judge. We want to start that as well. We just want to do it, you know, when it's right for the child to begin.
Well, arguably, according to mom, it'll never be right. And that's just the way it is, because mom is, and I'm not saying mom's being a bad mom. I'm just saying mom's being a protective mom. And that's okay. It's okay to be a protective mom. They're called helicopter moms, by the way. And my mom is still a helicopter mom, right? She's still a helicopter mom with her 2 children, me and my sister, right? And that's perfectly fine. She'll be that. And I encourage her to be that way until she is no longer walking on the face of the earth, because she needs to protect her children. And a mother will always protect her cubs. That is instinctual. It is understandable. I will never take that away from a mother. I would expect it. Okay. So I can understand why she's being protective. I can understand why she's being concerned. I can understand why, you know, she wants to do what she feels is in the best interest of the child. I have to balance that instinctual act that mom always, you know, kind of all moms for the most part, maybe not every single mom that walks, you know, that walks the planet, it acts the way Miss Mata does, but I would like to think that the great majority of them do. I have to balance that with Mr. Nash's interest in wanting to be a father, being accessible, being available. And so what we can possibly now start to have a conversation about is maybe for the next, I don't know, I think what would be reasonable would be for the next month, okay, for the next month, that we do 1 night a weekend. And then we phase that into 2 nights, month 2. And so I think that that's something reasonable. So it doesn't become, it's an adjustment phase for the child, but it's not a, you know, hey, you're going to be here overnight. I think that that's a reasonable request. And I think that that's something that would satisfy Mr. Nash's desire to be there for his child. And we haven't had any problems, arguably. And again, mom is still being protective. I get it. Dad wants to be a dad and he wants to have access. And so, Mr. Munoz, let's talk about that option with your client. And I think that that would be reasonable. I think everybody kind of walks away today with a visitation schedule that allows for him to have the child on a Saturday and keep it overnight till Sunday. And that allows that visitation to kind of play itself out how it's been. Now, soon enough here, though, I'm telling you guys, unless I hear otherwise, and I have to hear otherwise from medical doctors, I got to hear otherwise from some sort of professional experts, not just, mom being a protective mom, before we start doing a Friday to Sunday. Okay. And then that's going to be a standard visitation schedule that we're going to move into. So I think right now the child is with dad Saturday and Sunday. We can do a Saturday to Sunday overnight from Saturday to Sunday, one night. And then we move into a weekend visitation, standard visitation as we move forward. The question that's where I think, but again, I unless you're about to present me with some information, Ms. Martinez, that really causes me to have some great concern. That's why I asked those leading questions, predicate questions about whether there was any issues starting with.
Not at all, Judge. We weren't intending to introduce any type of medical or expert testimony today. We just wanted to give you all the facts and have you make a decision based on all the facts. And I appreciate that you're considering both sides on this. I do think that, it's reasonable what you're suggesting. And like I said, I'm sure my client believes it's reasonable as well. She is comfortable going into a standard visitation schedule. The issue that we're having between the parties comes down to his specific work schedule, and we don't want to necessarily agree to a deviation from standard possession. So that's the issue here.
And Your Honor, if I may just put that on the record, because I did submit those as exhibits. So Mr. Nash is a firefighter, so he actually has a schedule for the next year until like 2025. And as you know, and firefighters, they have weird shifts. So he only has, so he works a lot of those weekends. So if you looked at Exhibit A, for example, on the 1st and 3rd weekends of February, for example, he wouldn't even be able to do half those visits. And as we saw what happened with Matt's cash and carry, firefighters always need to be on the call, and it's not that easy to change the dates, which is why the calendars and the work schedules are printed out and created and generated years in advance.
I assume that the parties live in the same geographical area. This is not a situation where Mr. Nash lives in another.
No, they live close to.
Okay.
And so I would just ask the court, for example, because just this February on Exhibit A, he works on the days in red, right? So on the 19th and 26th, those are the weekends that he would have got with her under your previous temporary orders, which he can't see her. And if we were doing a standard visitation, if we were doing standard visitation, that Sunday the 6th and that Saturday the 19th would interfere with that. So it is an issue we're going to have to address. And we've been trying to switch days with the opposing party if possible, but that has not been the easiest thing to do.
Well, look, obviously I can sympathize with him, right? I really can. I can sympathize with the fact that his work schedule isn't ideal. But when it's not ideal, then there has to be some meeting of the minds and some sort of communication between the parties, and mom has to be amenable to it. And I get the fact that he's got his schedule set out so far in advance, but this is a modified schedule. This is some sort of an agreed schedule. Ms. Martinez, is there no agreement? Could there be no agreement based on the schedule that Mr. Munoz has put forward that lays this out for at least 2 years? Is there nothing that you can come to an agreement with respect to the visitations that would help the parties work out something? Or are they just, is your client so entrenched in her position of, no, it's going to be standard starts on Friday, it ends on Sunday, and that's just the way it's going to be because that's what you told me in our conversation, and that's my position?
Well, the presumption is that standard possession is in the best interest of the child. And, the way that she's been trying to co-parent with Mr. Nash has been difficult. They're trying to establish like a healthier relationship, a healthier way to communicate. But Judge, if you see some of these text messages, if you see some of the things that are said between the parties, you can see why it's so difficult to get them to agree. That's why my client has been trying to convince Mr. Nash to enroll in some type of parenting class together with them so that they can develop some type of way to resolve conflict and to communicate better. My client is not trying to keep the child from him. And the reason why she likes the standard possession is that it provides consistency on a weekend basis where she's not having to adjust her schedule. She also plans on starting school, this fall, along with Isla, because Isla's starting preschool this fall. And so the standard visitation schedule just allows for a lot more dependability, reliability, and it's a lot less burdensome to have to refer to his work schedule to see, whether or not she's able to make plans or, to make plans herself. So,
I will say this. I will say that from my experience, obviously, I've dealt with these cases more times than these two parties have had children, right? Because we deal with this as judges all the time. So I come with a lot more experience because of that, right? I will tell you, Ms. Martinez, and I will explain this to Ms. Mata, at some point, your work schedule, your school schedule is going to require that Mr. Nash be there to care for the child so that you can deal with your schedule as well. So it goes both ways. It's a double-edged sword. I'm just letting you know that because sometimes you only see the world from the table, from your seat at the table. And I always tell people, change positions at the table. Just change. Sit in his chair. You'll see the world differently because you're no longer looking at the world from the angle in which you're currently sitting at. So I get all that, Mr. Ramirez, Mr. Munoz. I'm sorry. I mean, at some point though, we need to talk about the fact that, his schedule doesn't, look, I'm looking at it at a distance here, but I'm seeing it and I see blue squares, green squares, and red squares.
He only works the days in red.
He only works the days in red.
And I would for example, this weekend, he wouldn't be able to get a Sunday off. He wouldn't be able to have her Sunday. But I would ask this court, if we're trying to do this temporary kind of.
It looks like the entire month of February, he can't have her on a Sunday.
He can't have her.
Maybe the last Sunday.
For the entire month of February of 2022, his weekend visitation will be disturbed.
Is that 2023, Eddie?
I think around 2023. Sorry, the 2022 one is not marked, but it is labeled on Odyssey as A.
Give me 1 second. We had 2023 up. Look at the next one. The next one has three exhibits, and it's probably one of them.
And I will note, Your Honor, that Isla is not currently in daycare or school, so now is the best time to kind of try to get these visits in and try to adjust.
Okay, so Friday, so basically, with the exception of this weekend, he has the rest of February Sunday off.
But on the 19th and 26th, he has Saturday.
And he works all day?
He goes in at 8 a.m. and he leaves the next day at 8 a.m.
Oh, so it's a 24-hour shift.
Yes, he can't leave. He does sleep there. They have beds, but he can't leave the premises.
Gotcha.
So for example, so just this February, he wouldn't be able to have her for 3 of those days.
And so what's your solution to that?
What we've been doing is doing off days. So whenever he can't have her on one of those days, we'll try to schedule it during the weekday. So
honestly,
it has been burdensome to have to communicate constantly and try to make up days that he doesn't, is not able to, especially because he gives her notice like the day of, like, hey, I can't get her tomorrow, or like, hey, I'm not going to be able to do that. And she has to find out, like, okay, so when can we schedule the makeup day for the dad? It has been burdensome.
And honestly, Your Honor, because I mean, we might just have to have a final order that, like goes like
Right.
states
That's
all
what
this.
I'm saying is like, let's set this hearing for final
But-
order so that we can come to a agreement on every single specific date that you're asking for. I don't think that is appropriate for temporary orders.
But
Like,
the final orders anticipates that, you know, the subject matter of the temporary, that he hasn't even had visits yet. So we're not going to know how they're going to go, the overnights.
So let's do this then. Let me go ahead and order every weekend, at least whenever he can, he'll have overnights. If he can't, that's perfectly fine. Miss Mata will just know that there won't be any visits, and it's not because he's not trying to, it's because of his work schedule. I'm looking at 2022 work schedule right here. Ms. Martinez may not already have a copy of it. If she doesn't, then Mr. Munoz, please send it to her. And I'll set this. I'll set this out for final hearing. Let's say like it looks as if he's gonna have the greater part of, well, he has 2 weekends in February that he can do an overnight from Saturday to Sunday, which is the 5th and the 7th.
No, he can't. See, all he would have is the 12th and the 13th.
13th, yeah, 12th.
So that's one overnight, and then so he only gets her on the 5th, the overnight, the 12th and 13th, and then the 27th.
Yes.
If Your Honor would.
I'm trying to accommodate overnights so that we can start to experience the overnight factor. That's all I'm trying to do. So
Judge,
whatever you all suggest.
would you consider just, you know, adding an overnight visitation, 1 per month or 2 per month, whatever you feel is appropriate right now until final orders?
Yeah, I'll do overnights as long as the schedule allows, and it'll be on the weekends. So let's do one night, whatever weekend he can make it work, let's make it work. Okay.
So one agreed overnight per month, essentially, until
I don't
final.
know if I don't know if it's going to be one. It could be multiple if there's multiple weekends that he can make it work. If he can't make it work, then it's only going to be one. You know, it's according to whatever he can make work. Because so for example, in the month of February, the only day that he can make work is the 12th and the 13th.
Yes.
And that's it. So that'll be the one overnight during the month of February. It'll be from Saturday the 12th through Sunday the 13th, and that's it. And that's the one weekend that he can make work. If we go into March, it seems like he can make the 12th and the 13th work, as well as the 19th and 20th. Right? He can make that work.
Yes, Your Honor.
Okay. And then I say we come back to try to finalize this sometime in early April, because it doesn't seem like he can make it work again until April the 16th and 17th. And really at that point, I'll already know whether this is working or not. And then y'all can work according to his schedule and come up with a calendar accordingly. Now, that doesn't mean that he is only entitled to visits then. He's entitled to visits on the weekends that he can. I'm just talking about overnights. At this point, I'm just talking about days at work for overnights. Does that make sense?
So
it does make sense, Your Honor.
I'm just trying to
finality as to the specific dates that you're ordering overnights, because Mr. Nash is very demanding and is very persistent with, you know, seeing the child.
Well, for example, I'll give you an example. He should be entitled to visit with a child this Saturday because he has Saturday off. Now, he's not entitled to overnights because he has to work early Sunday morning, but he's entitled to Saturday, right? So he should get this Saturday, the 5th. And
yeah,
then,
we've been following his every weekend, you know, every weekend when he's able to, he's been getting her.
So then let me just be perfectly clear about it. On the 5th, he's going to get her, but it's not going to be overnight. On the 12th, he's going to get her, but it will be overnight. And then unless it's by mutual agreement, he's not going to see the child again until the 6th of March. And then he'll have overnight on the 13th and on the 12th and 13th of March. And then he'll have overnight on the 19th and 20th of March. And then he'll have her on the 2nd of April. And he'll have her on the 9th of April. And then we'll come back in mid-April to see if we can finalize it. Now, if they can talk about another schedule that can work for them, great. But I'm just trying to accommodate his schedule and overnights and on weekends. And I'm not gonna throw the child off by putting it overnight on a Wednesday and a Tuesday, because when I go to standard, it's gonna be standard unless it's by mutual agreement.
Right, right. And standard is every other weekend, not every weekend. So, but I understand that this month and next month, he'll only actually get her overnight, maybe one or two times
Right.
per
But
month.
I caution you to counsel your client to be open to the idea of whenever his schedule works, because she's going to need the help here soon too. And I don't want to hear what I usually hear was, well, I can just leave the child with my parents, and so I can just kind of shun him because it's going to be every first, third, and fifth, whether he likes it or not. And if he can't make it work, tough. And I may need the help. I'm talking about I as in her. She may be looking at it from the perspective of she needs the help, but she's got some assistance from, grandparents that will help. He's going to have the right of first refusal. And then we get into all those things where I agree with you. You know what? Parenting classes is a great idea because they should go and try to learn how to communicate with each other better. So let's do that. Mr. Munoz, do you have any objection, or does your client have any objection to that? Other than schedule.
As far as the, are you ordering parenting classes? Because
ordering that they go to parenting classes.
Okay, like separately or
I don't know, depending on what the counselor decides. I mean,
okay,
they may want to visit with them separately first and then try to bring them in together to see how they communicate with each other. I don't know how that works.
Sure. And just to be very clear, I mean, I just want to make sure in case there is a change in schedule, it'd be like the one overnight in February and the 2 in March.
Unless his schedule changes, but then he's got to give her notice.
Okay.
He's got to give her at least 48 hours notice. 48 hours.
48-hour notice.
So he gets her the weekend. So we're back with the weekends, Saturday, Sunday, overnights where possible during those. And if his schedule changes, he's required to give her 48 hours notice.
And then he can exercise the weekends if he wants to. Yes. But if she's amenable to any other schedule because they communicate well and she needs help and they're going to trade off, hey, listen, I got to be out of town and I got to go to go on a business trip and I can't take the baby. Will you take the baby this weekend? And he can make it work. Then he can have her on a Wednesday. Hey, all those things have to happen. I mean, we deal with them as parents in a married situation. My wife has a meeting and I got to pick up the kids from school. It is what it is. I mean, I got to do something. I got to tell my office, hey, I got to leave at 3. So cut hearings. And I tell you guys, hey, listen, I got to go. I got to go pick up my sick child at school because I got to go do what I got to do. I mean, parents do that. That's part of life. Okay.
Yes, Your Honor.
There's a lot more commonality between them. I've seen some really, really bad situations. And Ms. Vale, she's over there listening. She's been a part of some really, really bad situations and we've made it work. This is not a bad situation. And Ms. Vale can attest to that. We've been a part of worse, 10 times worse, and we've made it work. Your clients seem to be very, very much amenable to each other based on what I've heard and based on what I see. So let's make it work.
Yes, Your Honor.
Okay. April 6th is our reset date for final hearing, 9:30.
April 6th, 9:30.
Thank you,
And
Judge.
if you guys want to exchange the visitation schedule for overnights, go ahead and enter into an order or submit an order to the court and I'll sign off on it. Okay.
Thank you, Judge.
All right.
Thank you, Your Honor.
Thank you. Yes, okay, George, I see you there under Judy Soto.
Yes, Judge, we're here, Judge. I don't know if it's possible, Judge, if I could be in a breakout room with Ms. Arlene just for like 2 minutes.
Sure, let me put you there. All right, I'm gonna open up the chat. There, you guys can go and meet in there.
Thank you, Judge.
All right, Mr. Lopez, what do you have?
Good morning, Judge. I need to prove up a divorce.
So I had Miss Talia Ramirez, Mr. Lopez, who has been logging on and having some difficulty. I'm gonna read the chats just real quick. So in fact, you can probably follow it along in the chats because it's open to everybody. It says, I can't hear. And then Carlos says, log out and go back in, Ms. Ramirez. She says, it doesn't work. Can't hear anything. Can the court be postponed? I can't hear anything. And then she called the court. She says, I'm having technical difficulties. So is it possible that we just maybe reset this so that she can have, I mean, she's been clearly expressing to the court that she's having some technical difficulties.
Judge, we'll follow any of the instructions that the court gives us, but if the court is going to give a reset, we ask for one.
I don't want
sometime in February.
Yeah. No. I was thinking maybe next Wednesday.
Okay, perfect.
Yeah, perfect. Okay, let me go ahead and do that. Let me go do next Wednesday, which is the 9th, February 9th, 2022 at 9:30. And that way we can let her know that it was been reset so she can make arrangements to get her system up and running.
Your Honor, I am sorry.
I will tell you that she logged on multiple times.
I'm sorry, Judge. I am not available that day. I have immigration hearings in Harlingen. Can I have another date?
How about Monday, the 7th?
Monday, the 7th at 9:30 is acceptable, Judge.
Okay. We're going to let her know that we moved it to the 7th. And again, she logged on. I'm not going to lie. She probably tried to log on at least 5 times with me, logging off, logging back on, logging off, logging back on. I mean, it was a repetitive game as I was hearing other cases about logging her back in. So clearly she's made an effort. And so for that reason, I think it's appropriate that we give her some time to fix her issues.
All right, Judge.
Okay.
Thank you. Can we be excused?
You're excused. Thank you.
Thank you.
So Mr. Mario Sanchez is also excused. And I have Bill Trevino. Are you available, Mr. Bill Trevino?
Yes, Your Honor.
Good morning, sir.
Good morning.
You are married to, do I pronounce it Aliyah?
Aliyah.
Aliyah Trevino.
Yes, sir.
And to your knowledge, is Miss Aliyah Trevino, I know she's not present. Was she looking to be present? Did she communicate?
I don't believe so.
Okay. Let me just see real quick. Did you submit a final order to the court? Let's open up that final decree. Let's make sure that, let me go to the last page. Who signed it? She signed off on it. To your knowledge, did she have an opportunity to review the final decree of divorce, Mr. Trevino?
Yes, sir.
Okay, perfect. Let me go ahead and have you raise your right hand. Do you sort of tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Is your true and correct name Bill Trevino?
Yes, Your Honor.
And Mr. Trevino, you are the petitioner in this divorce action, is that correct?
Yes, Your Honor.
All right. Prior to filing this petition for divorce, had you lived in the state of Texas for 6 months?
Yes, Your Honor.
In the county of Hidalgo for 90 days?
Yes, Your Honor.
During the course of your marriage, were any children born or adopted?
No, Your Honor.
To your knowledge, is Aliyah Trevino expecting any children at this time?
No, Your Honor.
Was any community property acquired during the course of your marriage?
No, Your Honor.
Okay, to your knowledge, is Ms. Trevino requesting a name change?
Not that I know of. I don't think she actually ever changed her name.
Okay. All right, I'll leave it as is. I'm not going to touch that subject issue. I will say that if she does want to change, obviously the style says Trevino, so it's Bill Trevino versus Aliyah Trevino. So at some point, the style says Trevino. I don't know if Trevino was her maiden name. I'm assuming not.
No, sir. No.
Okay. If she wishes to change her name, she'll have to file a petition at a later date.
Okay.
Has your marriage to Ms. Trevino become insupportable as a result of a conflict of personalities, which destroys the legitimate ends of the marriage relationship? Meaning, there's no expectation of you all being husband and wife and you're asking for a divorce?
Yes, Your Honor.
Okay. And you've signed off on this final decree of divorce, is that correct?
Yes, Your Honor.
And you're asking the court to grant you a divorce?
Yes, Your Honor.
Court's going to take judicial notice of all documents in the court's file, including the waiver of citation, which was executed by Aaliyah Trevino on September 20th, 2021. It was returned to the clerk September 21st, 2021. It's been on file for the requisite period of time. A final decree of divorce has been submitted to the court with the signatures of Mr. Bill Trevino and Aaliyah Trevino. And as such, the court's going to go ahead and grant the divorce at this time with all relief that's been read into the record and prayed for by way of pleadings. Mr. Trevino, your divorce is hereby granted. We'll sign off on it right now. You can get a certified copy of it this afternoon from the clerk's office.
Thank you, Your Honor.
You're excused.
Thank you.
All right, that leaves us with George and Darlene, who are in a breakout room. Court's going to go ahead and take a short break.
Are you guys ready?
Oh,
Yes,
yes,
we're
we
ready.
are.
Sorry.
We reached an
Okay,
agreement.
let me
There
get
seems to be an
Judge on the line.
echo. No, you're not.
All right. I have George there. I can see him. Ms. Vale,
Yes, Your Honor.
do y'all have an
We-
announcement or
We do,
you?
Judge.
We reached actually an agreement for the final of this order, Your Honor.
Okay,
I am going to ask that there be a translator. My client understands Spanish better. I do believe that is also true for the other person as well. I think they're primarily Spanish speakers, Your Honor.
That's
And
correct.
so if we could have a translator, just so we spoke in Spanish, Your Honor, so we are sure they understand what the agreement is. I just want to be sure that the record reflects they understand the agreement.
sure. Are you going to be just reading the agreement into the record and then?
That's correct, Your Honor.
Okay, so then go ahead, Ms. Vale or Mr. Munoz. Y'all can read it into the record. Just kind of piece it so that Carlos can translate for your client.
Okay. Your Honor, this is an agreement. There's a motion for enforcement filed by my client, Adán Vázquez. Your Honor,
Hay una moción para enforzar que fue archivada por su cliente Adán Vázquez.
okay, the parties have agreed as follows, Your Honor.
Ambos se han puesto de acuerdo
That commencing the first, third, and fifth weekends of the month for 3 weekends in a row, my client will only do overnight for Friday.
se pusieron de acuerdo que los primero, tercero y quinto fines de semana, por 3 semanas al hilo, va a haber que se queda el niño por la noche, nomás el viernes.
Right, and then, Your Honor, on the Saturdays and Sundays, he will return the child on Saturday at 6 o'clock to mom.
Y sábado y domingos va a regresar el niño a mamá el 6 de la tarde.
Right, and on Sunday, it'll start just for days, since there's no overnight, it'll start at 10 a.m., which is what their current schedule is.
Y
Except
domingo,
it'll go till 6.
y domingo va a visitar, va a empezar de la visita a las 10 de la mañana, como no se va a quedar por la noche y termina a las 6.
Then, Your Honor, after the third, then we will commence doing standard visitation which is from 6 to 6.
Y ya después del tercero, entonces van a empezar con la visitación estándar, que va a ser de 6 a 6.
Now, my client will also, because standard has during the school year that he gets Thursdays from 6 to 8 p.m., he will also be exercising that visitation. And of course, in any case that either the parents have agreed as follows, that if the child or one of them,
I'm sorry, give me a second.
I
You could say-
apologize. It's
No
my
worries.
fault,
Did you say 6 to 10 or 6 to 8? On Thursday.
6 to 8 on
Okay.
Thursday.
Y el señor Vázquez, como tiene visitaciones y por eso la escuela, los jueves va a tener visitaciones de 6 a 8. All right.
In addition to that, Your Honor, the parties have agreed as follows, that they will follow as much as possible COVID orders about for masking in terms of the face in the event that somebody should result with COVID and the child happens to be the person that has the COVID, and that the child stays with that person until that is cleared to come into the other deal, just as required normally, Your Honor, under the rules. So,
y ambos se van a poner de acuerdo que van a seguir los requisitos de COVID, usando mascarilla, y si el niño llegara a salir positivo para COVID, se va a quedar con el padre que lo tenga en posesión.
or if the parent has COVID, Your Honor,
O si el padre tiene COVID.
or any of their family members.
O
In
cualquier
other
de
words,
sus
if they have
familiares.
been exposed.
Si son esposados.
And so that until that gets resolved, Your Honor, hopefully we come out of this quicker. And Your Honor, the only thing I'm gonna ask, Your Honor, and we didn't agree on says this, I am asking the court to impose some type of not sanctions to come in, but in case that for some reason I have to come back to reinforce this second order, whether it be that he has to pay her attorney's fees or she has to pay him attorney's fees for having to come back if I have to reinforce this order a second time, Your Honor, on this regards. That's all I'm asking for, Your Honor. I'm not saying the other side agreed to that, Your Honor. I did tell him that I had to seek something of that nature.
Yo lo que no llegaron a un acuerdo, pero va a pedir por parte de que si tienen que regresar a reforzar esta orden, entonces van a haber sanciones que sea uno pague los honorarios del abogado del otro o viceversa.
Judge, and we agree to everything Ms. Vale's correct, except for the last part. There's disagreement as to how the first order came into play. My client contends that, there was no visitation for years and years. And then I understand Ms. Vale had to file this order and the court addressed it. And the only thing that we're asking is if that should happen, and I don't think that it will, Judge, that the court address it at the time that it happens and makes a decision accordingly at that time based on the facts before the court.
Right. I think that would probably be fair. Just, I don't know what's going to ultimately be the reason for coming. It could be something that's very superficial and nominal, and this, the court can view that at the time. So I'll definitely take it into account at the time, Ms. Vale.
Okay, Your Honor, if I can just have, because these things tend to be forgotten. And then for him, it's a real financial sacrifice to come in and hire an attorney.
Sure.
Please.
No, I totally understand that. If it's something that she's causing him frustration and it's a true frustration that has caused him to hire an attorney, I will definitely take that into consideration. But if it's something that he's just, sometimes there's, I'll call it a ticky-tack. There's little ticky-tack things that are thrown and are used as, volleys to affect people, and they use a court system. I'll take that into account and, make a decision appropriately. But yeah, absolutely.
Okay, that'll be fine, Your Honor. Then that's the totality of the order. I'd ask the court, if I may ask my client.
Go ahead.
Okay, Mr. Adan, you heard what I told the court?
¿No oyó lo que le dije a la corte?
Sí.
Yes.
And that's your agreement, is that correct?
Y ese es su acuerdo, ¿correcto?
Sí.
Yes.
Okay, I have nothing further, Your Honor. I ask the court to approve this agreement as a final order. So I believe in the best interest of the child.
George, do you have any questions for your client?
Yes, Judge. Ms. Soto, you read the agreement as it was read into the record by Ms. Vale. You heard that, correct?
¿Usted oyó el acuerdo como lo leyó el abogado Veo al acta?
Sí, correcto.
Yes,
And
correct.
you're in agreement with what was read into the record?
¿Y usted está de acuerdo con lo que se leyó al acta?
Sí, estoy de acuerdo. Solamente,
Yes, I'm in agreement. Only that.
Okay, Judge. We're asking the court to approve the agreement, Judge.
The court will go ahead and approve the agreement that's been read into the record. Go ahead and submit an order, and as long as the attorney sign off on it, I'm okay with it.
That'll be fine, Your Honor. We'll go ahead and do that. If they don't sign off, I'll probably file a motion for entry, Your Honor.
Sounds good.
Perfect.
All right, Your Honor.
That's
Thank
all
you.
I have.
Thank you, Your Honor.
Excused.
We make use.
Both of y'all are excused.
Thank you.